Assalamualaikum and hi everyone. We are from group 2 are going to discuss about defenses of accident in criminal law. Meet our group member. We have Al-Falah, Nur Salinda, Nur Afza, Is Sabrina and Anis Mansara. In this presentation, we are going to discuss about the defenses of accident using the ILAC method.
Hi, Assalamualaikum warahmatullahi wabarakatuh. We are from group 2 that will present to you about a question of Arjan and Basman. Arjan and Basman, both of them are licensed shooters. And this case starting last weekend when both of them went into jungle to shoot birds. And they took up in different positions. Arjan saw the leaves swaying and heard the sound of an animal crawling closer to him. Believing it was a tiger, Arjan shot at the moving object. However, he found out that it was a dead body of his friend Basman. Arjan was subsequently charged for causing death to Basman. And now I will pass it to the next presenter. Thank you.
Thank you, Linda. So, the issue is whether Arjan can raise defense of accident. I'll pass to the next presenter, Falah, for the law.
Now, I will continue with the law part. According to Section 80 of Penal Code Act 574, which stated that nothing is an offence which is done by accident or misfortune or with any criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. In order to anybody to be defended with the defense of accident, the committed act must be unintentional and pure accidental. If a person does the act with intention and her lawful knowledge to cause harm, the defense of the accident cannot be raised. By referring to the conditions for the defense of the defendants to be valid and acceptable, there are two conditions that need to be fulfilled, which is, firstly, the committed act must be lawful, and secondly, the accused person had exercised the proper care and caution. There are 5 elements that need to be fulfilled in order to anybody to defend themselves under this defense of accident, which is the first element is the alleged offense was the result of an accident or misfortune. I give you a case to prove this element. In the case of Ratnam versus R 1937, in order to constitute a defense, the act must be unintentional and a pure accident. Where the accused intentionally causes harm or does an act with the knowledge that it is likely to cause harm, it is not an accident. When the act causing it is not done with intention of causing it, and when the consequences of its occurrence is not so probable that a person of ordinarily prudence ought to take reasonable precautions under circumstances in which it was done against its occurrence actually. So that is under the first element. The second element is the act giving a rise to the accident was done without any criminal intention and without the lawful knowledge. The criminal intention is the purpose of doing an act forbidden by the criminal law without just cause. However, in order to defend ourselves or anybody with the defense of accident, the committed act by us or anybody who committed that act must be without criminal intention. If the person have the criminal intention, they will not be defended under this defense of accident. So that is the second element. The third element is the act must be lawful and was performed in a lawful manner by lawful means. It needs to be performed in a certain way which is not in contravention of the law and using a legal or proof tool. So, for this element, we refer to the case of Koh Pong Ing versus Public Prosecutor 1977. In this case, the defendant had informed the victim that she intended to commit suicide and shoot the victims a knife. The defendant hugged the victim and told her not to go ahead with the suicide and tried to wrench the knife from her in order to prevent the defendant from committing suicide. In doing so, the victim unfortunately lost his balance and accidentally fell onto the knife. The court held that Section 80 was applicable in this case since the defendant had been performing the lawful act of showing the victim the knife. It would have different if the defendant was actually had the intention to attempt to commit suicide when victim intervened, since attempted suicide is an offense under Section 309 of Penal Code. Basically, in this case, the defendant is just want to show the knife that she wants to use to commit suicide, but don't want to attempt to commit suicide or to kill the victim. Right, so that is the third element. This fourth element, which is the last element that needs to be fulfilled in order to defend ourselves or anybody in the defense of accident, is the act was done with proper care and caution. To make this element clear, I give a case to prove or to make it this element more to make it this element clearer. Right, we refer to the case R versus Ong Chun 1938. The utmost care would have required the defendant to warn victim that he was going to release his grip on victim's hand. There would have not been a reasonable precaution for the defendant to take, since victim would have been alerted to this eventuality and prepared himself to start when the defendant released his grip. So that's proof the act was done with the proper care and caution as the element of the defense of accident that need to be fulfilled. So I hope everything is clear about the law for our case. Now, I will pass this floor to the next presenter to explain about the application.
My name is Nur Afzal binti Muhammad Fakhur Razi. My matric number is 064910. So I'm in charge for the application part. There are 4 elements that need to be fulfilled in order for Arjan to be defended by the court under the defense of the accident. The first element is the alleged offence was the result of an accident or misfortune. By applying to this case, Arjan is fulfilled this element as he was mistaken about the noises that belonged to an object that closer to him. He thought that it was a tiger, so he has shot at the object. However, he found out that it was the dead body of his friend best man. The second element is the act giving a rise to the accident was done without criminal intention or knowledge. Arjan fulfilled the second element as he did not know that the object he had shot was his companion best man. Next, for the third element is the act must be lawful and was performed in a lawful manner by a lawful means. Both Arjan as well as best man happen to be a licensed shooter, which means it is not an offense for Arjan if he went into the jungle to shoot bird with rifle or gun, and he also fulfilled this element. The last element is the act was done with proper care and caution. However, for this element, Arjan was not fulfilled as he did not be careful and proper care before he fired an object that he did not sure what is the object. Now I will pass to the next presenter.
For the conclusion is, in conclusion, Arjan cannot raise the defense of the accident because he did not fulfill the element.